Hello, everybody. This is Attorney Augustus Corbett, one half of the Defiant Lawyers. Each and every week, we bring you a legal analysis of some trending story having to do with politics, policies, personalities, or pop culture to empower you to defy an unjust legal system. If that interests you, please hit the subscribe button, like, share, comment, and click the bell so that we will notify you every time we upload one of these videos. So yesterday I was on a YouTube channel, one of my favorites. It's called The Regular Gun Guy. And it's a 2A community, mainly of African-American men who just love to hang out and enjoy their firearms and talk firearms and sometimes even talk the law. Well, just so happened yesterday, this group was in fact talking about a very recent case that was just handed down by a judge here, actually in my backyard, in the Dallas-Fort Worth area. In fact, it was a judge in the Northern District of Texas who handed down a decision regarding whether stabilizing braces on handguns or firearms are constitutional. And I promised to read the documents, to read the cases, and to do a video on it. So that's what I'm going to do in this video. But first, I got to finish reading all these documents. There are quite a few. I'm almost finished, but as soon as I finish, I'm going to come back and complete this video. Stay with me. Okay, I'm back and I have read the documents, so I'm ready to make some comments on this really important case. By the way, let me tell you the name of this case. It is Darren A. Brito et al., which means there are other plaintiffs, two other plaintiffs to be exact, versus Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly called the ATF. All right, so basically what this case is all about is the constitutionality of a new ATF rule that makes firearms fitted with a stabilizing brace, a short barrel rifle, and subject, therefore, to regulations of the NFA. All right. So the three plaintiffs believes that this new ATF rule is unconstitutional in a number of ways. The ATF believes that it's not, that it's necessary to save lives, etc. Now, the ATF has defined a rifle in such a way that it obviously did not include handguns, because anyone who has shot a rifle knows that in order to shoot a rifle, and I shoot a rifle left-handed, although I'm right-handed, you have to put the rifle up against your shoulder. Whereas with a handgun, obviously, you shoot it with one or both of your hands. It does not need to be braced up against your shoulders. So for years, for decades, in fact, the government obviously did not include handguns or pistols in the definition of rifles, but the ATF changed the rule or definition of what a rifle is. And the new definition includes handguns with stabilizing braces. Now, let me be even more specific. On January 31st, 2023, ATF published a new rule that clarified the statutory phrase designed, redesigned, made, or remade, and intended to be fired from the shoulder. Under the rule, this phrase now includes weapons equipped with a stabilizing brace that provides surface area, allowing the weapon to be fired from the shoulder, provided that other factors indicate that the weapon is designed, made, intended to be fired from the shoulder. These factors include measurements of the weapon's weight or the length of pull, the manufacturer's direct or indirect marketing, the likely use of the weapon in the general community, and whether the weapon is equipped with sights or scope with eye relief that require the weapon to be fired from the shoulder in order to be used as designed. Now, let me give you some background. So this stabilizing brace, the first one that was manufactured for folks with disabilities, many of them Vietnam veterans. And so a manufacturer created a brace that a person with a disability could use, which sort of set over the person's forearm, and then you would wrap a strap or two straps around the person's hand, thus giving that person who had suffered some sort of injury or was disabled the ability to stabilize the handgun better. Over time, those stabilizing braces evolved and they developed until they became sort of sitting on the back of the weapon. And some folks did, in fact, started using them by placing them on their shoulders and discharging them like a rifle. And many of those rifles, the barrels were less than 16 inches, which absolutely made it something that had to be regulated by the NFA. But the plaintiffs are arguing that the ATF has already said several times that using a stabilizing brace on a pistol does not qualify that pistol as a rifle or as a short barrel rifle. In fact, 2012, ATF said no, that does not qualify a pistol as a short barrel rifle. 2015, once again, the ATF said that a pistol with a stabilizing brace that is not intended to be fired from the shoulder is not a short barrel rifle. Did so again in 2017. Now, all of a sudden, on January 31st, 2023, ATF completely changed the rule and thus redefining whether or not a pistol with a stabilizing brace is in fact a short barrel rifle. And again, it says the statutory phrase designed, redesigned, made, or remade and intended to be fired from the shoulder. This phrase now includes weapons equipped with a stabilizing brace that provides surface area, allowing the weapon to be fired from the shoulder, provided other factors are met. So that covers a wide range of weapons, including pistols. And therein lies the problem, right? Because millions and millions and millions of people have bought these stabilizing braces based on what the ATF has declared in the past. And now all of a sudden, it is basically changing course. So as a result of that, 3 plaintiffs here in the Northern District of Texas, in fact, not just their case, but there is another case as well, Mock v. Garland is that case. And all of these cases are in the Northern District, and they are subject to rulings from the Fifth Circuit. So these plaintiffs, Mr. Brito and his fellow plaintiffs, filed suit against ATF, asking the judge basically to find that this new rule violates the Second Amendment, violates separations of powers and non-delegation principles, conflicts with the NFA's definition of rifle, and some other alleged violations of this particular rule. Now, rather than waiting for this case to matriculate all the way up probably to the U.S. Supreme Court, the plaintiffs in this case, Mr. Brito and his fellow plaintiffs, asked the court to issue a preliminary injunction. Now, preliminary injunction is something that would stop ATF from enforcing this rule. So the judge in this case said essentially, because there is a very similar case that is before the Fifth Circuit, I'm not going to do anything right now. I'm going to put a stay on this case in my court pending the outcome of the Fifth Circuit's opinion in the Mock v. Garland case. Now, in the Mock v. Garland case, the Fifth Circuit found that the ATF rule was unconstitutional. Let me see if I can find what they said exactly. Okay, here it is. The Fifth Circuit held that the rule was not a logical outgrowth of the proposed rule that the monumental error was prejudicial and that it must be set aside as unlawful. So when the Fifth Circuit ruled that in the Mock v. Garland case, the judge in the Brittle case said, okay, now we got some guidance. So I'm going to lift the stay in my court so that we can proceed. So he then began to proceed with his case, and to the plaintiff's delight, he issued a preliminary injunction. Now, when plaintiffs are asking for a preliminary injunction, there are three things they have to show the court. Number one, they have to show the court that there's a good chance that they're going to win. Second, they have to show the court that if the preliminary injunction is not issued, then they will suffer irreparable harm. And the third thing is that it's in the public's interest to grant the injunctive relief. Those three things. And in this judge's opinion, he believed the plaintiffs were able to show all three. Thus, he issued an injunction. And so did the judge in the Mock v. Garland case. Now, I want you to understand that once the Fifth Circuit ruled that the ATF rule was unconstitutional, then the Fifth Circuit remanded it back to the lower court here in the Northern District of Texas. Both cases, by the way, are here in the Northern District of Texas. And because the Fifth Circuit had ruled on the rule, then the judge in the Brittle case, again, had guidance and issued the preliminary injunction. So the case will matriculate and continue through the legal system, probably ending up in the U.S. Supreme Court, because keep in mind, the preliminary injunction is temporary. So both judges are going to have to continue allowing the litigants to litigate their cases until they make final decisions, which then at that point, the entire case will probably be appealed back to the Fifth Circuit. And from there, it is likely to end up in front of the U.S. Supreme Court, regardless of who wins and or who loses. So as it is right now, the ATF cannot enforce this new rule because the judge granted the movant's preliminary injunction. In fact, let me read some language from the judge's order. It says, likewise, the court is certainly sympathetic to ATF's concern over public safety in the wake of tragic mass shootings. The rule embodies salutary policy goals meant to protect vulnerable people in our society. But public safety concerns must be addressed in ways that are lawful. This rule is not. Judge goes on to say, for the foregoing reasons, the court grants the motion and stays the rule in its entirety. That means stops the rule, which means the ATF cannot enforce the rule. Now, initially, I wasn't sure if this was going to be something restricted to this particular appellate district, the Northern District, this area here, where, again, the Fifth Circuit rules and this court has jurisdiction. But just given the language here, as well as the fact that the ATF is a part of the federal government and its rule would have had and did have national import, I'm now of the opinion that this preliminary injunction applies nationwide. That is huge. That is really, really big. So millions of gun owners around the country can breathe a sigh of relief because of this injunction. But don't celebrate too much because, as I said earlier, the litigants still have the right to litigate their cases, and they will litigate those cases. We know the government is definitely going to appeal this, but gee, they're appealing it back to the Fifth Circuit, perhaps, or to the U.S. Supreme Court, which consists of 6 very conservative, pro-Second Amendment justices. So I think that this preliminary injunction is going to stand or become a permanent injunction. And I believe the U.S. Supreme Court is going to side with the judge in this case, thereby protecting, stabilizing braces for the future. That's exactly what I think will happen here. Okay, so thank you for listening. I am Attorney Augustus Corbett. It was a pleasure doing this video. Thank you once again, and you have a good day. Until the next time. Bye.
That Corbin and Corbett legal team, fighting for the rights of the people. That father-daughter team, investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. The team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbett, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple. To obtain a favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the best and most